Hi everyone, Louisiana Succession Attorney Brad Scott here. I want to talk to you today about something called a partition action and what that is. This is a common situation we run into quite often. We get a lot of phone calls about, and it comes up when you co-own something with other people. So the most common example is that you inherited property and the succession has been completed, and maybe you have a few siblings or maybe some aunts and uncles that you co-own the property with. Usually it's a piece of real estate. The situation usually occurs where somebody wants to sell the property and somebody doesn't. Or they just can't get along on how to co-own the property and who's going to do what with it. In this situation, we always get the phone call saying, well, what can we do here? I want to sell it. They won't agree to sell it. We can't get a real estate agent to get into the house because they won't let them in the house. What is our legal remedy here? How do we break up this co-ownership if we can't get on the same page? Well, the solution to that, or at least the legal solution to that, is what's called a partition action. In a partition action, what you do is you open a legal proceeding. All the co-owners of the property are brought into that legal proceeding and made a party to that action, and what you're asking the court to do is to break up that co-ownership. Now, there's two different ways the court can break up co-ownership. If you're dealing with a big tract of land, maybe a 100-acre piece of property, and you had multiple heirs, it may be a situation where the court can come in and actually divide the property up into equal pieces and give each person their piece, and then they can go about their own business and sell it or do whatever they want with it or keep it or build on it. Most of the time, though, that's not the situation. A lot of times we're dealing with a house, maybe a residential neighborhood or something of that sort, where you can't just readily divide it in half or cut it up. In that situation, what the court can do for you is they can order that the property be sold through a partition sale. And in that situation, the most common situation that happens is the court appoints somebody to be in charge, and that person is authorized by the court to then hire a real estate agent. Then that real estate agent will list and sell the property. Once the property is sold, the net proceeds are deposited into the court, and then anyone who has an ownership interest in the house can make their claim to those funds. But the co-ownership is now split up. You don't co-own the property anymore. So this is how you get out of co-owning it with somebody if you are co-owning property that you may have inherited. It's like I said, it's a very common situation. So I just want you to be able to understand what that legal solution is. That's really the only option you have if people aren't negotiable and getting on the same page. I hope this helps answer some of your questions. If you have any other estate-related questions and you need some help, give us a call. We'll see if we can help you. If we can't help you, we'll try to point you in the right direction and to someone who can help you. Until next time, take care.